Hi, I'm Simon Deakin and I'm Principal Investigator on this project, which is concerned with the relationship between legal systems and financial systems in the so-called rising powers. And more generally, we're concerned with the relationship between legal change and economic development in so-called transition systems like Russia and China. What does it mean to move from being a so-called socialist economy to a market one? What's the role of the legal system in that transition process? And what's the role of the financial system? And are we seeing financial development in the rising powers? In what way is that either being promoted or is it being retarded by the nature of the legal system, by the nature of the state, and by the quality of the rule of law in these countries? And our team is a mixed team of lawyers, economists, and sociologists from a number of universities: Cambridge, Oxford, Leicester, Loughborough, Durham and Newcastle. So it's a large team. And what we're doing is, first of all, coding legal change over time, so-called leximetrics, which is something we developed in an earlier ESRC-funded project. And these charts show what's been happening to the formal law on shareholder protection in the four BRIC countries since the mid-1990s. This is from our earlier study. And as you can see, there's a rising trend in each case. So formally, shareholder rights, property rights, rights of investors are being strengthened in each of these systems. And that's very, very much because of the World Bank agenda associated with the Doing Business report. And there's some reflexivity here. The World Bank initially developed a methodology for arguing the case for this type of reform in the early 1990s, and the Doing Business reports had their own version of leximetrics. Ours are somewhat different. What we see is the impact of the World Bank policy. So many of these countries were adopting policies which the World Bank recommended, and there's been an improvement, if that's what it really is, in shareholder protection at a formal level over time as a consequence of legal change. Our coding methods differ somewhat. We have a more consistent time series. I can't go into it in too much detail, but we're using the same methodology for the new study, but expanding the number of years we're covering. So we're going to go back in time to about 1990 and forward in time to 2014. So we'll have 25 years worth of data for about 30 countries altogether. And with that many years of data, we can do rather more interesting time series econometric analysis, which is also part of this study. These are more general trends for 30 or so countries. You can see that over time, developed countries do have stronger shareholder protection than developing ones, transition ones, but transition systems in developing countries are catching up. Something which lawyers are interested in are common law countries, the US, the UK, different from civil law countries, Germany, France, and also the rising powers are, with the exception of India, civil law countries. Actually, it is the case that common law countries have stronger rights, property rights for shareholders than civil law countries, but civil law countries were catching up in this period. The other part of our research is to do field work, and we're doing field work in each of the four countries, and those interviews have begun. Let me just say something briefly about our methodology here. Obviously, at one level, we're collecting national level macro data, and we're using national level economic data to run time series regressions. So that's very abstract, very high level, but it gives us a big picture. Largish sample of countries, 30 or so countries, very long time series for this sort of data. But we supplement that by detailed case study work in each of the countries, face-to-face interviews, obviously to try and deepen our knowledge of the particular processes, which we know we're not going to capture with that big macro level data. So this explicitly a multiple method study. So the Russian case is especially interesting for many reasons, one of which is the knock-on effects of Russian financial development on the UK legal system in particular. The Berezovsky-Abramovich litigation was the most expensive litigation conducted ever in an English court. And what's interesting is, of course, that the events of this dispute did not take place in London. Right, so it all took place in Russia, but thanks to the flexibility of English commercial law, the English courts were unable to hear this case. They did so at very great expense. So one of our respondents told us Russian law and justice is much underestimated, and apart from anything else, it's a lot cheaper. And this case could have been resolved in the same way, much more cost effectively in Moscow. I'm sure that's true, by the way. But Moscow is making a big push, as I'm sure you know, to become, or has been, to become an international financial centre. At the bottom here is the insignia of the Supreme Arbitrage Court, which is the main Russian court dealing with commercial disputes. And it's a very interesting court and a very modern and progressive one, although it's now being merged with the Supreme Court, which may not be a very positive development. The Russian government policy has been under Medvedev and more recently under Putin, the same policy has been maintained of having liberal regulation of financial markets, as they put it, in accordance with regulations, but enterprises should operate more at arm's length from the state. This at least is the ideal which the Russian federal authorities say they're trying to attain. And so then we're doing field work with lawyers, judges, business people in Moscow and in London over the past 6 or 9 months or so. And it's at a very early stage. But obviously one gets with field work a lot more rich data, I would say, about what's really going on, what the perceptions of the actors are. And I think the key message to come out of all this is that I think Russia has moved on very significantly from the late 1990s period. Everybody knows the story of UKOS and to some extent TNK-BP, and Russia is associated with a particular kind of Wild East form of law and finance. But actually, the legal system has developed and matured in certain ways. This is not to say there isn't any longer corruption in Russia, but it seems to be a different sort of corruption. So we're told you can no longer directly bribe a judge, okay, but there are different ways of having influence within the system. Most striking of all, I think, is that the Russian state is much more effective than it was a decade and a half ago. Its state capacity has massively increased, but not everybody thinks this is a good thing. So from the point of view of commercial lawyers and business people, they're worried that a more effective state is a more effective predatory state. So yes, it is not always a good thing that judges and bureaucrats are better paid. It's a complicated story. The state, business people think, is just some people in power and their friends. But I especially like the idea that Russian society is a series of layers and the leaders can only touch the top layers. I'm sure that's right. And this may make one think somewhat differently about Russia and the image of the all-powerful political elite and governing class in Russia. Everything is a conspiracy. So these are just early thoughts from our field work. We'll be rolling this out for the other countries. We've begun recently in Brazil and India and have been researching longer term in China. I could have told a similar story about the other countries, but this is just a snapshot. Thank you very much.